Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 15 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between September 22nd, 2020 and September 29th, 2020. We will start this week with criminal law. Commonwealth v. Bonnett is a criminal case regarding the trial court's denial of a request for a Frye hearing in a murder case. Briefly, the facts. The defendant was alleged to have been at the home of a former girlfriend in the evening hours. Shortly after he was seen at the house went up in flames and his former girlfriend and her children were killed in the fire. At the trial, the Commonwealth called an expert regarding the causation of the fire. The defendant alleged that the expert's analysis at trial that the fire was incendiary did not comport with the National Fire Protection Association publication 921, the scientific methodology deemed acceptable in the fire investigation community. The trial court denied the request for a Frye hearing. When an expert is relying on novel science, a Frye hearing is held to determine if the methodology underlying the novel scientific evidence has gained general acceptance in the scientific community. In this case, the trial court found that the science being relied upon was not novel, and therefore a Frye hearing was not required. The Superior Court found no abuse of discretion on the part of the trial court, noting importantly that the defendant failed to make any showing that the expert's testimony was based on novel scientific evidence or in contravention to the National Fire Protection Association publication 921. The defendant also raised an issue regarding the sufficiency of evidence, but the court found that the sufficiency argument was waived because he did not adequately identify the errors that he intended to challenge on appeal. Commonwealth v. Epps is an appeal of a dismissal of a PCRA petition without a hearing following a jury trial conviction for murder, robbery, and conspiracy. Epps was the getaway driver in a robbery that went south, resulting in the murder of two men. In Epps's PCRA petition, he claims that his trial counsel was ineffective. To be entitled to relief on an ineffectiveness claim, the petitioner must establish that 1. The underlying claim had arguable merit, 2. No reasonable basis existed for counsel's action or failure to act, and 3. He suffered prejudice as a result of counsel's error, with prejudice measured by whether there is a reasonable probability that the result of the proceeding would have been different. It is also important to note that a petitioner is not entitled to a PCRA hearing as a matter of right. The PCRA court can decline to hold a hearing if there is no genuine issue concerning material fact, the petitioner is not entitled to relief, and no purpose would be served by any further proceeding. The petitioner claims that his counsel was ineffective for failing to object to certain comments made by the prosecution during trial. When reviewing prosecutorial misconduct, the review requires the court to evaluate whether the defendant received a fair trial, not a perfect trial. The Superior Court found that the petitioner failed to demonstrate how the prosecutor's comments affected the fairness of his trial, and therefore he was properly denied relief on that issue. The petitioner raised several additional claims regarding ineffectiveness, which the Superior Court found were all without merit, and that the petitioner was properly denied relief on all of his PCRA claims. Commonwealth v. Shires is a criminal case addressing whether or not the defendant's violations of the conditions of supervision imposed by the State Board of Probation and Parole were sufficient to revoke his probation. Defendant was sentenced in 2002 to 9 to 18 years of incarceration, followed by 20 years of probation. The only condition of probation imposed at the time was payment of fines, costs, and restitution. The defendant later signed and agreed to follow 28 additional conditions imposed by the board. There was no docket activity until 2016, whereby the court entered an order that the defendant must comply with the additional probation conditions. This order was served on the public defender, but no evidence suggests that it was ever served on the defendant. In 2017, defendant was charged with violations of his probation and resentenced to prison. Defendant appealed, claiming that the additional conditions of probation imposed by the board could not be used to revoke his probation. He claims he was aware the conditions applied to parole, but was not aware they applied to his probationary sentence. The Supreme Court concluded that while only the trial court can set conditions of probation, the board and its agents may impose conditions of supervision that are germane to, elaborate on, or interpret any condition of probation that are imposed by the court. In other words, the trial court may impose generalized conditions of probation, and the board may impose more specific conditions. The Superior Court found that because the 2016 order was never served on the defendant, it could not be a basis to revoke defendant's probation. Therefore, the only pertinent condition of probation was the order issued in 2002 requiring payment of fines, costs, and restitution. Because the alleged violations were related to the special conditions imposed by the board, the court must determine if they are germane to, elaborate on, or interpret the conditions imposed by the court. Because the special conditions were not at all related to payment of fines and costs, they cannot be enforced against the defendant. The revocation of probation is reversed and the original judgment of sentence is reinstated. Commonwealth v. Williams is a PCRA case which addresses whether timely filed pro se PCRA petition can be accepted when there is still counsel of record. In this case, the defendant was convicted at trial and wanted to appeal. He was unable to afford to hire his attorney for the appeal, and no counseled appeals were filed on the defendant's behalf. The defendant did, however, file 2 timely post-sentence letters raising several issues. The letters were treated as the product of hybrid representation and forwarded to his attorney of record. As a general rule, pro se filings submitted by petitioners who have attorneys are treated as legal nullities. However, the court has recognized that a counseled defendant may act on his own to protect important rights where counsel remains technically attached but is no longer serving the client's interests. Under the circumstances of this case, the general rules prohibiting hybrid representation are not implicated and the defendant's post-sentence rights are reinstated. In Commonwealth v. Brown, the defendant pleaded guilty to driving under the influence. It was a first offense in 10 years. He was sentenced to 3 to 6 months incarceration. The defendant appealed, arguing an illegal sentence because statutorily, a first offense DUI has a minimum term of 6 months probation. As a preliminary matter, the defendant, after pleading guilty, may only appeal matters concerning the jurisdiction of the court, the validity of the guilty plea, and the legality of the sentence. If there is no agreed-upon sentence, he may also challenge the discretionary aspects of the sentence. The defendant argues that his sentence is illegal and that only a 6-month probationary sentence may be imposed. The Superior Court rejected the defendant's argument and finds that the minimum sentencing provisions of 6 months probation does not represent the only sentence available to the court. The trial court sentence in this case was consistent with controlling authority, requiring the court to consider imposition of applicable guideline range sentences when they exceed statutory minimums. Commonwealth v. Mickley is a criminal case regarding the constitutionality of SORNA, the Sexual Offenders Registration and Notification Act. The defendant was convicted of various sexual offenses, and part of his sentence was a 25-year registration requirement under SORNA. He filed a petition to bar application of SORNA. The petition was denied, and this appeal followed. On appeal, the defendant raised several issues of constitutionality regarding SORNA, primarily that SORNA results in the denial of due process, violates the separation of powers doctrine, and that a 25-year registration requirement is a cruel and unusual punishment. The Superior Court, in reviewing the record, determined that the factual record was not sufficiently developed in the trial court to allow the court to render an opinion on the merits of the appeal. Though defendant's counsel attempted to present evidence, no evidence was in fact presented at the post-sentence motions. Therefore, in accordance with precedent, the order denying the motion is vacated and the case is remanded to the trial court for a hearing to present evidence consistent with this opinion. In a second case addressing SORNA, Commonwealth v. Smith is an appeal brought after the defendant was denied relief from his lifetime requirement to register pursuant to SORNA. The defendant's motion was denied without addressing any of the substantive claims, as the court determined that it was an untimely PCRA petition. All claims that are cognizable under the PCRA must be raised in a timely PCRA petition, and while the scope of the PCRA is broad, it is not without limitation. For example, the PCRA is not intended to provide relief from collateral consequences of a conviction. The court here finds that registration requirements under SORNA are collateral consequences to a conviction and therefore does not fall within the purview of the PCRA. Further, the courts have declined to find the PCRA or any other procedural mechanism the exclusive method for challenging SORNA requirements. Here, because the motion to be removed from lifetime registration was not an untimely PCRA petition, the case is remanded to the trial court to address the merits of the petition. We will be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
In the matter of Commonwealth v. McLaughlin, the defendant filed a writ of coram nobis claiming that the judge should have recused himself during trial because he was under criminal investigation at the time of the trial. Following his trial, appellant filed a number of PCRA petitions, all of which were dismissed by the court. Historically, a writ of coram nobis is generally available based on facts not before the court when the judgment was entered. The writ provides a way to collaterally attack a criminal conviction for a person who is no longer in custody and therefore cannot seek habeas relief. However, it is well settled that where a petitioner's claim is cognizable under the PCRA is the only method available to obtain collateral review. Additionally, if a petitioner raises a claim that is cognizable under the PCRA but has completed service of his sentence, he is ineligible for relief under the PCRA. In this case, the defendant is seeking review of judicial bias. Judicial bias is a violation of due process, and due process violations are cognizable under the PCRA. As this is a claim that could be brought under the PCRA, and because the defendant has completed service of his sentence, he is not entitled to any relief. Commonwealth v. Barr is a Commonwealth appeal from a trial court order granting a motion to suppress evidence obtained following a traffic stop. In this case, the defendant was stopped for a traffic violation. During the contact, the officers claimed they smelled marijuana. The defendant presented the officers with his medical marijuana card indicating that he is allowed to possess marijuana. The officers searched the car and discovered marijuana shake, a small amount of marijuana in a plastic baggie, as well as a firearm. The defendant filed a motion to suppress, claiming the officer lacked probable cause to search the vehicle. The trial court granted the motion, holding that the odor of marijuana no longer provided probable cause to search a motor vehicle because a substantial number of Pennsylvania citizens can now legally consume marijuana. The Superior Court found that while the odor of marijuana does not alone provide probable cause to search a vehicle because marijuana is not always illegal as it once was, the court found that lawful users of medical marijuana do not surrender their Fourth Amendment rights merely because other citizens continue to possess marijuana illegally. However, this does not mean the odor of marijuana cannot even be considered. The Superior Court rejects the trial court opinion that because marijuana has been legalized in Pennsylvania for medical purposes, the smell of burnt or raw marijuana is no longer indicative of an illegal or criminal act. Rather, the odor of marijuana may still be indicative of an illegal or criminal act because marijuana remains generally illegal. This is especially true when other circumstances suggest that the detected marijuana is not in compliance with the Medical Marijuana Act. Ultimately, the court found the odor of marijuana alone, absent any other circumstances, cannot provide individualized suspicion of criminal activity when hundreds of thousands of Pennsylvanians can lawfully produce that odor. What it does provide to police is general, probabilistic suspicion of criminal activity based on the fact that most citizens cannot legally consume marijuana. Thus, it is a factor that can contribute to a finding of probable cause, assuming some other circumstances supply more individualized suspicion that the activity is criminal. In this case, the Superior Court finds that the record is inadequate as to whether the officers had probable cause to search the car. The case is remanded to consider the facts in making a determination of probable cause consistent with this opinion. Now that the criminal cases are completed, we move on to a couple of property law cases. Pineda v. Perry arises after a trial court entered an order permanently enjoining the Perrys and the other appellants from denying Pineda access to his property via Coates Alley. Clear back in 1968, in a quiet title lawsuit regarding the property, a judge ruled that Coates Alley was to be mutually used and enjoyed by the parties to the lawsuit, as well as other property owners in the subdivision whose lots were originally conveyed. This current action was bought in 2019. Pineda purchased his property in 2016 and was able to use Coates Alley to access his property from both directions. Pineda claims that subsequent to his purchase of the property, the appellants erected fences across Coates Alley, denying Pineda access to his property. After a hearing, the court entered an order granting Pineda's request and requiring the fences to be removed within 10 days of the order. This appeal follows. When lots are sold as part of a recorded subdivision in which a street has been plotted by the grantor, as is the case here, the purchasers acquire property rights in the use of streets. Specifically, all purchasers of property in a subdivision acquire an easement over all platted roads in the subdivision plan. This easement of access is a property right appurtenant to the land that cannot be impaired or taken away without compensation. As Pineda was the purchaser of a lot in the subdivision, he acquires property rights in the use of the streets, including Coates Alley. There is no evidence to suggest that he was compensated for the preclusion of his use of Coates Alley, and therefore the easements of access should not have been impaired or taken away from him. The Superior Court found that the trial court properly granted injunctive relief, ordering the Perrys and other appellants to remove all impediments preventing Pineda from accessing his property through his easement over Coates Alley. In re Appeal of Ridge Park Civic Association is a property case addressing zoning variances. The property at issue are two parcels zoned for single-family residential. The applicants for the zoning variation propose to consolidate the two parcels, demolish the existing house, and erect 9 single-family townhomes in 3 sets of 3. Because the current zoning is single-family, a variance must be granted in order to approve the application. In determining if a variance shall be granted, the board must find that each of the following criteria must be satisfied. The denial of the variance would result in unnecessary hardship. The variance will represent the minimum variance that will afford relief. The variance will be in harmony with the purpose and spirit of the zoning code. The variance will not substantially increase congestion in the public streets or endanger the public health, safety, or general welfare. The variance will not injure the appropriate use of adjacent conforming property. The variance will not adversely affect transportation or unduly burden water, sewer, school, park, or other public facilities. The variance will not adversely and substantially affect the implementation of an adopted plan for the area, and the grant of the variance will not create any significant environmental damage. To determine if there will be an unnecessary hardship, the board must find that there are unique physical circumstances or conditions peculiar to the property, and that the unnecessary hardship is due to such conditions and not due to conditions created by the zoning code. That because of those physical circumstances, there is no possibility that the property can be used in strict conformity with the provisions of the zoning codes, and that the use variance will not alter the essential character of the neighborhood. In this case, the peculiar physical circumstances relate to geotechnical issues that result in a significant cost to build, and that cost can only be offset by a larger number of properties. Here, the Superior Court found that the factual record supports the findings of the board that a use variance meets the criteria. However, the trial court failed to make quantifiable measurements because they erroneously believed that the minimization doctrine did not apply to a use variance. Therefore, the case is remanded to the trial court to make appropriate findings as to the quantitative aspects of the minimum variances necessary for this to be a viable project. The final case of the week is a 10th Amendment case addressing the constitutionality of a federal statute. In Gustafson v. Springfield, the Superior Court must decide whether a federal statute, the Protection of Lawful Commerce in Arms Act of 2005, or the PLCAA, bars a lawsuit arising from the shooting death of Gustafson's 13-year-old son. The PLCAA is a federal statute that dictates that a qualified civil liability action may not be brought in any federal or state court against members of the gun industry. A qualified civil liability action is further defined and essentially bars any lawsuit with very limited exceptions. To date, all courts that have considered the PLCAA agree that if none of the exceptions exist, the plaintiff or a third party commits any crime with the firearm or ammunition at issue, and that firearm or ammunition has crossed state lines, the PLCAA immunizes the gun industry from a plaintiff's lawsuit. Accordingly, in this case, per the plain language of the statute, the PLCAA bars the Gustafsons' lawsuit. However, the court goes on to address the constitutionality of the PLCAA. The Pennsylvania Superior Court rejects the trial court and the Second Circuit's view that the PLCAA falls within one of the three categories of constitutional Commerce Clause legislation. Congress did not rationally link the PLCAA to any burden upon interstate commerce that the Constitution recognizes. The court goes on to state that the PLCAA is unsustainable. It grants the gun industry immunity regardless of how far removed the interstate commerce the harm arises. Congress's attempted exercise of its Commerce Clause power in the PLCAA without a recent or concrete tie to interstate commerce puts every victim of a crime or tort within the reach of congressional regulation. The court finds that as a result, the PLCAA is a violation of the 10th Amendment. The court finds that congressional tort reform bills like the PLCAA have no place in the federal system, and that tort laws and statutes reforming them are an exercise of police power reserved to the states under the 10th Amendment. That's a wrap for this week. Thank you again for joining us.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.